On April 30th, 2026, Fifth Circuit Judge James Hoe wrote a scathing opinion that demolishes the dangerous and unusual test courts use to uphold gun bans. By the end of this video, you will know how this could change every court analyzes gun laws, and if you own firearms states call dangerous and unusual, those bans might be on borrowed time. So let's get into it.
A federal appeals court judge just issued an opinion that gun control advocates are calling the death of reasonable restrictions, and gun rights supporters are calling constitutional text restored. On April 30th, 2026, Fifth Circuit Judge James Hoe wrote a scathing opinion that demolishes the dangerous and unusual test courts used to uphold gun bans. His exact words: "The Second Amendment is not a second-class right subject to entirely different rules than other Bill of Rights guarantees. This could change how every court analyzes gun laws, and if you own firearms states call dangerous and unusual, those bans might be on borrowed time." Hit that subscribe button right now, because this judicial opinion sets up the legal framework that could strike down assault weapon bans, magazine capacity limits, and dozens of other restrictions within the next 18 to 24 months. Judge Hoe just gave gun rights lawyers the blueprint for winning cases. Here's what happened. On April 30th, 2026, in a case involving federal firearm restrictions, Fifth Circuit Judge James Hoe issued a concurring opinion. Legal scholars call one of the most important Second Amendment writings since Justice Thomas's Bruen opinion. Judge Hoe directly confronted how courts use dangerous and unusual language from District of Columbia v. Heller to uphold gun bans. He argued this test has been twisted and used to evade constitutional protections. Citing United States v. Wilson and Hollis v. Lynch, Judge Hoe demonstrated courts have been limiting gun rights out of constitutional fear, rather than following constitutional text and history. Let me break down exactly what Judge Hoe said, why the dangerous and unusual test has been a loophole for gun control, how the First Amendment comparison destroys gun ban logic, what United States v. Wilson and Hollis v. Lynch reveal about judicial evasion, which gun laws are now vulnerable, and your action plan for supporting litigation that uses this framework. Number one, what Judge Hoe actually said in his April 30th, 2026 opinion, the exact language reshaping Second Amendment law. The core holding: courts have seized upon dangerous and unusual from Heller as means of avoiding rigorous constitutional analysis. Just as fear cannot justify limiting First Amendment, fear of firearms cannot justify treating Second Amendment as second-class right. Constitution does not permit judicial rewriting based on contemporary anxiety. On Bruen compliance, Supreme Court in Bruen provided clear instructions. Examine text, history, tradition, not policy preferences, not public safety concerns, not judicial danger assessments. When courts substitute dangerous and unusual for historical analysis, they violate Bruen and Constitution. On First Amendment comparison, we don't allow speech restrictions merely because speech can be dangerous. We don't permit prior restraints on press because journalism might expose sensitive information. We don't ban unpopular religions because beliefs seem unusual. Why then tolerate firearm restrictions based solely on assertions arms are dangerous and unusual? On common use, Heller's dangerous and unusual language must be read in context. Supreme Court distinguished arms protected, those in common use for lawful purposes, from those not protected, unusual military weapons not commonly owned. Courts inverted this, calling commonly owned firearms unusual simply because effective. If you're finding this helpful, imagine what you'll learn in my next video, where I reveal the 5 gun cases about to reach the Supreme Court that will use Judge Ho's framework to strike down assault weapon bans nationwide. Subscribe so you don't miss it. Number 2, the dangerous and unusual test explained. How it became gun control's loophole. Understanding this test is critical. Heller's original language. District of Columbia versus Heller, 2008, said Second Amendment protects arms in common use for lawful purposes. It noted the amendment doesn't protect dangerous and unusual weapons like M16s, fully automatic military rifles, a narrow exception for military weapons not commonly owned. How courts twisted it. Lower courts flipped this. They started calling commonly owned firearms dangerous and unusual to justify bans. AR-15s with 20+ million in civilian hands, dangerous and unusual. Standard magazines owned by tens of millions, dangerous and unusual. The test became circular. Guns are dangerous because effective, unusual because courts say so. The logical problem: all firearms are dangerous. That's their purpose. If danger alone justifies bans, the Second Amendment protects nothing. If effectiveness makes firearms unusual, only ineffective firearms are protected. This renders the right meaningless. Bruen's fix. Supreme Court in Bruen, 2022, required historical analysis. Courts must find founding era or Reconstruction era analogs. But courts continued using dangerous and unusual to avoid this work. Judge Hoe is calling out this evasion. Quick legal note: This is educational information about judicial opinions and constitutional law. This is not legal advice. Gun laws are complex and changing. Always consult qualified attorneys for specific legal situations and verify current law before making decisions. Number 3, the First Amendment comparison. Why Judge Hoe's analogy destroys gun control logic. Speech can be dangerous. First Amendment protects dangerous speech. Investigative journalism exposes classified information. Political speech incites protests. Religious speech challenges government. Yet we don't ban speech categories because they're dangerous and unusual. Press freedom despite risks. We don't ban journalism types because press is powerful. Newspapers can destroy reputations, reveal secrets, influence elections. No dangerous and unusual press test. Religious liberty for unpopular beliefs. First Amendment protects minority religions. Mainstream society finds unusual. We don't ban religions because practices are uncommon or beliefs seem dangerous. Why different treatment? If we don't limit other constitutional rights based on danger and unusualness, why tolerate this test for gun rights? Either Second Amendment is constitutional right entitled to same protections, or it's a second-class right subject to different rules. Constitutional principle. Rights aren't limited by contemporary fears. Bill of Rights protects rights even when exercising them seems dangerous or unusual. Fear cannot justify judicial rewriting of constitutional text. Hey, 73% of people watching right now aren't subscribed. Join the 50,000 gun owners getting these critical court updates first. Subscribe, because when assault weapon bans fall based on this reasoning, you need to know immediately. Number 4, United States versus Wilson and Hollis versus Lynch. Cases Judge Hoe cited proving judicial evasion. Wilson challenged federal prohibition on firearm possession after felony conviction. Lower courts used dangerous persons. Reasoning without rigorous historical analysis, policy judgment, felons are dangerous, substituted for constitutional analysis. Lynch challenged federal ban on interstate handgun transfers. Courts called interstate transfers dangerous and unusual, without examining founding-era law on such transfers. Policy substituted for history. Judge Hoe's point, both cases show courts avoiding Bruen's historical test by asserting danger. No founding-era analysis, no Reconstruction-era analysis, no historical tradition, just this seems dangerous to uphold restrictions. This evasion violates Bruen and the Constitution. The pattern, post-Bruen, courts give lip service to historical analysis, then conclude restrictions are valid because firearms or persons are dangerous. This substitutes judicial preferences for constitutional requirements. Number 5, why second-class right language matters and changes legal arguments. Second-class right concept. When courts apply different analytical frameworks to different constitutional rights, they create hierarchy. If First Amendment gets strict scrutiny but Second Amendment gets dangerous and unusual balancing, Second Amendment becomes inferior. Heller's warning, Justice Scalia explicitly warned against treating Second Amendment as second-class right. Yet lower courts did exactly that by creating exception-filled frameworks. Judge Hoe's reinforcement. By repeating second-class right language and citing First Amendment parallels, Judge Hoe forces courts to explain why gun rights deserve less protection than speech, press, or religious liberty. There's no principled answer. Litigation impact. Gun rights lawyers are incorporating this framework. Every assault weapon ban brief now includes assault weapons in common use, 20+ million AR-15s. Banning treats Second Amendment as second class. Courts don't ban dangerous speech, they shouldn't ban effective firearms. Legal pressure. Courts must either apply consistent standards or openly admit treating gun rights as inferior. Either outcome benefits gun rights. Number 6, which gun laws become vulnerable in the timeline. This opinion provides the roadmap. Assault weapon bans. States ban AR-15s by calling them dangerous and unusual. Judge Hoe's framework destroys this. 24+ million AR-15s proves common use. Banning them treats Second Amendment as second class. Magazine limits. States limit magazines to 10 rounds. Judge Hoe's framework, standard 30-round magazines in common use, hundreds of millions owned. Effectiveness doesn't make them unusual. We don't limit speech because it's effective. Feature bans, pistol grips, adjustable stocks, flash suppressors banned as dangerous features. Judge Hoe, common features on commonly owned firearms, banning because they make firearms effective treats rights as second class. Carry restrictions, states expanding sensitive places to most public areas. Judge Hoe demands historical analysis, not contemporary danger assertions. Founding era didn't ban carry in most public spaces. Timeline. Cases in litigation will use this reasoning in supplemental briefs. April-June 2026. New cases filed May-August 2026. Circuit decisions Q4 2026, Q2 2027. Supreme Court cases 2027 term. Number 7, your action plan under this new framework. Support gun rights organizations using this framework. SAF, FPC, GOA are incorporating Judge Hoe's reasoning into litigation. Join and donate. If in states with assault weapon bans or magazine limits, document compliance while supporting challenges. When these laws fall, likely within 18-24 months, you'll want clean record. Spread awareness. Most gun owners don't follow circuit opinions. Share this information. Constitutional protections are strengthening. Engage legislators. In states considering new gun control, testify using this framework. This law treats the Second Amendment as second-class right. Courts are rejecting this. Prepare for victory. When assault weapon bans fall, expect surge in demand. Research what you want, budget accordingly. Vote November 2026. Judicial appointments determine whether judges like Hoe sit on federal courts. Elections determine judicial philosophy. Here's the bottom line. Fifth Circuit Judge James Hoe's April 30th, 2026. Concurring opinion demolished the dangerous and unusual test courts use to uphold gun bans. He argued courts are treating the Second Amendment as a second-class right by applying standards they'd never apply to First Amendment rights. Judge Hoe's First Amendment comparison is devastating. We don't ban speech because it's dangerous. Don't restrict press because it's powerful. Don't limit religion because it's unusual. Why ban firearms? Because they're effective. Citing Wilson and Lynch, Judge Hoe proved courts evade Bruen's historical test by substituting danger assertions for constitutional analysis. Vulnerable laws, assault weapon bans, magazine limits, feature bans, expanded sensitive places, all rely on dangerous and unusual reasoning. Judge Hoe demolished. Timeline. Active cases use this framework immediately. New cases filed. Circuit decisions through 2027. Supreme Court review likely. Your action. Support litigation. Document compliance. Spread awareness. Engage legislators. Prepare for victory. Vote November. Subscribe right now because I'm tracking every case using Judge Hoe's framework and will alert you when assault weapon bans fall. Judge Hoe just gave gun rights lawyers the constitutional roadmap to victory. Now use it. Thanks for watching. Next video reveals the 5 assault weapon ban cases already incorporating Judge Hoe's second-class right framework and when they'll reach the Supreme Court.